I'm going to now proceed with the reading of the jury instructions to you. I'm going to ask the bailiff to provide you with printed copies of those instructions. What I'd ask you to do is follow along as I read them. Don't read ahead. Just follow along if you care to. You'll be permitted to take these instructions with you into the jury deliberation room, so you should feel free to mark on these instructions if you wish. They're yours to keep. If I encounter a typographical error or something, I may draw your attention to it and ask you to correct it. So if you would, just follow along as I do read these to you. So members of the jury, all of the evidence has been presented, and it's now your duty to decide from this evidence what the facts are. You must then apply the law that I'm about to give you to those facts, and it's absolutely necessary that you understand and apply the law as I give it to you, not as you think it is or might like it to be. This is important because justice requires that everyone tried for the same crime be treated the same way and have the same law applied. The defendant has entered a plea of not guilty. The fact that the defendant has been charged is no evidence of guilt. Under our system of justice, when a defendant pleads not guilty, the defendant is not required to prove the defendant's innocence. The defendant is presumed to be innocent. The state must prove to you that the defendant is guilty beyond a reasonable doubt. A reasonable doubt is a doubt based on reason and common sense, arising out of some or all of the evidence that has been presented, or the lack or insufficiency of the evidence, as the case may be. Proof beyond a reasonable doubt is proof that fully satisfies or entirely convinces you of the defendant's guilt. You are the sole judges of the believability of witnesses. You must decide for yourselves whether to believe the testimony of any witness. You may believe all, any part, or none of a witness's testimony. In deciding whether to believe a witness, you should use the same tests of truthfulness that you use in your everyday lives. Among other things, these tests may include the opportunity of the witness to see, hear, know, or remember the facts or occurrences about which the witness has testified, the manner and appearance of the witness, any interest, bias, prejudice, or partiality the witness may have, the apparent understanding and fairness of the witness, whether the testimony is reasonable, and whether the testimony is consistent with other believable evidence in the case. You are the sole judges of the weight to be given to any evidence. If you decide that certain evidence is believable, you must then determine the importance of that evidence in light of all other believable evidence in the case. Evidence has been received tending to show that in an earlier time a witness made a statement which may conflict or be consistent with the testimony of the witness at this trial. And you must not consider such earlier statement as evidence of the truth of what was said at the earlier time because it was not made under oath at this trial. If you believe the earlier statement was made and that it conflicts or is consistent with the testimony of the witness at this trial, you may consider this and all other facts and circumstances bearing upon the witness's truthfulness in deciding whether you believe or disbelieve the witness's testimony. If you find from the evidence that the defendant has admitted a fact relating to the crime charged in this case, then you should consider all the circumstances under which it was made in determining whether it was a truthful admission and the weight that you will give to it. Photographs, diagrams, and sketches were introduced into evidence in this case for the purpose of illustrating and explaining the testimony of a witness or witnesses. These photographs, diagrams, and sketches may not be considered by you for any other purpose. In this case, you have heard evidence from witnesses who have testified as expert witnesses. An expert witness is permitted to testify in the form of an opinion in a field where the witness purports to have a specialized skill or knowledge. As I have instructed you, you are the sole judges of the credibility of each witness and the weight to be given to the testimony of each witness. In making this determination as to the testimony of an expert witness, you should consider, in addition to the other tests of credibility and weight, the witness's training, qualification, and experience, or lack thereof, the reasons, if any, given for the opinion, whether the opinion is supported by facts that you find from the evidence, whether the opinion is reasonable, and whether it is consistent with other believable evidence in the case. You should consider the opinion of the expert witness, but you're not bound by it. In other words, you are not required to accept an expert witness's opinion to the exclusion of facts and circumstances disclosed by other testimony. There are two types of evidence from which you may find the truth as to the facts of a case: direct and circumstantial evidence. Direct evidence is the testimony of one who asserts actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain or group of facts and circumstances indicating the guilt or innocence of the defendant. The law makes no distinction between the weight to be given either to direct or circumstantial evidence, nor is a greater degree of certainty required of circumstantial evidence than of direct evidence. You should weigh all the evidence in the case. After weighing all the evidence, if you're not convinced of the guilt of the defendant beyond a reasonable doubt, you must find the defendant not guilty. Proof of motive for the crime is permissible and often valuable, but never essential for conviction. If you are convinced beyond a reasonable doubt that the defendant committed the crime, the presence or absence of motive is immaterial. Motive may be shown by facts surrounding the act if they support a reasonable inference of motive. When thus proved, motive becomes a circumstance to be considered by you. The absence of motive is equally a circumstance to be considered on the side of innocence. The defendant in this case is not testified. The law gives the defendant this privilege. This same law also assures the defendant that this decision not to testify creates no presumption against the defendant. Therefore, the silence of the defendant is not to influence your decision in any way. The defendant has been charged with first-degree murder of Jamison Jamie Kirk Hahn. Under the law and the evidence in this case, it is your duty to return one of the following verdicts. Number one, guilty of first-degree murder, or number two, guilty of second-degree murder, or number three, not guilty. First-degree murder is the unlawful killing of a human being with malice and premeditation and deliberation. Second-degree murder is the unlawful killing of a human being with malice, but without premeditation and deliberation. For you to find the defendant guilty of first-degree murder, the state must prove 5 things beyond a reasonable doubt. First, that the defendant intentionally and with malice killed the victim with a deadly weapon. Malice means not only hatred, ill will, or spite as it is ordinarily understood. To be sure, that is malice. But it also means the condition of mind which prompts a person to take the life of another intentionally, or to intentionally inflict serious bodily harm which proximately results in another's death without just cause, excuse, or justification. If the state proves beyond a reasonable doubt that the defendant intentionally killed the victim with a deadly weapon, or intentionally inflicted a wound upon the victim with a deadly weapon that proximately caused the victim's death, you may infer first that the killing was unlawful, and second, that it was done with malice. But you are not compelled to do so. You may consider this, along with all other facts and circumstances, in determining whether the killing was unlawful and whether it was done with malice. An 8-inch chef's knife is a deadly weapon. Second, the state must prove that the defendant's act was a proximate cause of the victim's death. A proximate cause is a real cause, a cause without which the victim's death would not have occurred, and one that a reasonably careful and prudent person could foresee would probably produce such injury or some similar injurious result. Third, that the defendant intended to kill the victim. Intent is a mental attitude, seldom provable by direct evidence. It must ordinarily be proved by circumstances from which it may be inferred. An intent to kill may be inferred from the nature of the assault, the manner in which it was made, the conduct of the parties, and other relevant circumstances. Fourth, that the defendant acted with premeditation, that is, that the defendant formed the intent to kill the victim over some period of time, however short, before the defendant acted. And fifth, that the defendant acted with deliberation, which means that the defendant acted while the defendant was in a cool state of mind. This does not mean that there had to be a total absence of passion or emotion. If the intent to kill was formed with a fixed purpose, not under the influence of some suddenly aroused violent passion, it is immaterial that the defendant was in a state of passion or excited when the intent was carried into effect. Neither premeditation nor deliberation are usually susceptible to direct proof. They may be proved by circumstances from which they may be inferred, such as the lack of provocation by the victim, conduct of the defendant before, during, and after the killing, use of grossly excessive force, brutal or vicious circumstances of the killing, and the manner in which, or the means by which, the killing was done. Second-degree murder differs from first-degree murder in that neither specific intent to kill, premeditation, nor deliberation are necessary elements. In order for you to find the defendant guilty of second-degree murder, the state must prove beyond a reasonable doubt that the defendant unlawfully, intentionally, and with malice wounded the victim with a deadly weapon, thereby approximately causing the victim's death. If you find from the evidence beyond a reasonable doubt that on or about the alleged date the defendant acting with malice killed the victim with a deadly weapon, thereby approximately causing the victim's death, that the defendant intended to kill the victim, and that the defendant acted after premeditation and with deliberation, it would be your duty to return a verdict of guilty of first-degree murder. If you do not so find or have a reasonable doubt as to one or more of these things, you will not return a verdict of guilty of first-degree murder. If you do not find the defendant guilty of first-degree murder, you must determine whether the defendant is guilty of second-degree murder. If you find from the evidence beyond a reasonable doubt that on or about the alleged date the defendant intentionally and with malice wounded the victim with a deadly weapon, thereby approximately causing the victim's death, it would be your duty to return a verdict of guilty of second-degree murder. If you do not so find or have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty. The defendant has been charged with the attempted first-degree murder of Nation Richard Hahn. For you to find the defendant guilty of this offense, the state must prove two things beyond a reasonable doubt. First, that the defendant intended to commit first-degree murder, and second, that at the time the defendant had this intent, he performed an act which was calculated and designed to accomplish the crime, but which fell short of the completed crime. Again, first-degree murder is the unlawful killing of a human being with malice, with premeditation, and with deliberation. Malice means not only ill will or spite, as is ordinarily understood, to be sure, that is malice, but it also means the condition of mind which prompts a person to take the life of another intentionally, or to intentionally inflict serious bodily harm, which proximately results in his death without just cause, excuse, or justification. If the state proves beyond a reasonable doubt that the defendant intentionally inflicted a wound upon the victim with a deadly weapon, you may infer first that the defendant acted unlawfully, and second, that it was done with malice, but you are not compelled to do so. You may consider this along with all other facts and circumstances in determining whether the defendant acted unlawfully and with malice. An 8-inch chef's knife is a deadly weapon. Premeditation means the defendant formed the intent to kill over some period of time, however short, before he acted. Deliberation means that the defendant acted while he was in a cool state of mind. This does not mean that there had to be a total absence of passion or emotion. If the intent to kill was formed with a fixed purpose, not under the influence of some suddenly aroused violent passion, it is immaterial that the defendant was in a state of passion or excited when the intent was carried into effect. Again, neither premeditation nor deliberation are usually susceptible of direct proof. They may be proved by circumstances from which they may be inferred, such as lack of provocation by the victim, conduct of the defendant before, during, and after the attempted killing, and threats and declarations of the defendant. If you find from the evidence beyond a reasonable doubt that on or about the alleged date the defendant intentionally attempted to kill the victim with a deadly weapon and performed an act designed to bring this about, but which fell short of the completed crime, and that in performing this act the defendant acted with malice, with premeditation, and with deliberation, it would be your duty to return a verdict of guilty of attempted first-degree murder. If you do not so find or have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty. The defendant has been charged with assault with a deadly weapon with intent to kill, inflicting serious injury. For you to find the defendant guilty of this offense, the state must prove four things beyond a reasonable doubt. First, that the defendant assaulted the victim by intentionally and without justification or excuse, stabbing or slashing Nation Richard Hahn. Second, that the defendant used a deadly weapon. A deadly weapon is a weapon which is likely to cause death or serious bodily injury. An 8-inch chef's knife is a deadly weapon. Third, the state must prove that the defendant had the specific intent to kill the victim. Intent is a mental attitude seldom provable by direct evidence. It must ordinarily be proved by circumstances from which it may be inferred. You arrive at the intent of a person by such just and reasonable deductions from the circumstances proven as a reasonably prudent person would ordinarily draw therefrom. And fourth, that the defendant inflicted serious injury. A knife wound severing tendon and nerves is a serious injury. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant intentionally stabbed or slashed Nation Richard Hahn with an 8-inch chef's knife and that the defendant intended to kill the victim and did seriously injure him, it would be your duty to return a verdict of guilty. If you do not so find or have a reasonable doubt as to one or more of these things, you would not return a verdict of guilty of assault with a deadly weapon with intent to kill, inflicting serious injury, but must consider whether the defendant is guilty of assault with a deadly weapon, inflicting serious injury. Assault with a deadly weapon inflicting serious injury differs from assault with a deadly weapon with intent to kill, inflicting serious injury, in that the state is not required to prove that the defendant had the intent to kill. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant intentionally stabbed or slashed Nation Richard Hahn with an 8-inch chef's knife, thereby inflicting serious injury upon the victim, it would be your duty to return a verdict of guilty. If you do not so find or have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty. Now, members of the jury, you've heard the evidence and the arguments of the parties. If your recollection of the evidence differs from that of the parties, you are to rely solely upon your own recollection. Your duty is to remember the evidence, whether called to your attention or not. You should consider all the evidence, the arguments, contentions, and positions urged by the parties, and any other contention that arises from the evidence. The law requires the presiding judge to be impartial. You should not infer from anything that I have done or said that the evidence is to be believed or disbelieved, that a fact has been proved, or what your findings ought to be. It is your duty to find the facts and render a verdict reflecting the truth. All 12 of you must agree on your verdict. You cannot reach a verdict by majority vote. When you have agreed upon a unanimous verdict as to each charge, your foreperson should so indicate on the verdict forms. After reaching the jury room, your first order of business will be to select a foreperson. You may begin your deliberation when the bailiff delivers the verdict forms to you. Your foreperson should lead your deliberations. When you have unanimously agreed upon a verdict as to each charge and are ready to announce them, your foreperson should record your verdicts, sign and date the verdict forms, and notify the bailiff by knocking on the jury room door. You will then be returned to the courtroom and your verdict will be announced. Now, you've heard me mention, ladies and gentlemen, the verdict forms. They will be delivered to you shortly after you retire to begin your deliberations. Now, don't begin your deliberations until you receive this packet. Simply, when you retire, select your foreperson. Shortly thereafter, you'll receive this packet. Inside this packet, you will find the verdict forms. They're self-explanatory. They have the 3 offenses that have just been described to you. Several of the offenses have lesser included offenses. Those are also on here, so I believe they're self-explanatory. They also have a place for the foreperson to sign and date the verdict forms once unanimous verdicts have been reached. Also in this packet, you'll find a pad of paper and a pen. In the event, during the course of your deliberations, you have a question or request for the court, the way you let us know that is by simply writing that question or request on a slip of paper. Summon the bailiff by knocking on the jury room door. The bailiff will bring me your request or question, and I'll review it with counsel to see how we can best respond to you. It may be something as simple that you just want to take a break, or it may be any other sort of question or request that you may have of the court, but that would be the way I would ask you to go about doing that. All right, now, Mr. Ryan, you have been with us for the past several weeks as our alternate juror. What I'm going to ask you to do is I'll ask the bailiff to take you in the deliberation room, and if you have any personal property back there, go ahead and grab that now. Then wait in the hallway while I finish the instructions to these jurors, send them back for deliberation. I'll have a few more words for you at that time. So, bailiff, if you could accompany Mr. Ryan to the deliberation room to have him retrieve his personal property. Bailiff, has Mr. Ryan cleared the jury deliberation room?
Yes.
And is he in the hallway?
Yes, sir.
All right, very good. So, ladies and gentlemen, I'll ask you now to retire to the deliberation room to, again, your first order of business, select your foreperson. When you receive this packet, you may begin your deliberations. You may take with you to the deliberation room the notes and the jury instructions that I've given to you, if you'll follow the bailiff to the deliberation room. Presence of the jury counsel, are there any objections, corrections that you wish to put on the record to the reading, to the jury instructions as read, or to the form of the verdict sheets?
Not from the state, Your Honor.
All right, in that case, bailiff, I'll ask you to deliver the verdict packet to the jurors. And on your way back, if you would bring Mr. Ryan back in, I'll have a few words for him.
Yes.
Mr. Ryan, I want to thank you very much for your service as an alternate juror thus far in these proceedings. I cannot release you yet. What I'm going to ask you to do, sir, is to go to the jury lounge, make yourself comfortable, and await further instructions from me. I will contact you through Ms. Van, the jury clerk downstairs, with further instructions, certainly before the end of today. And I will have further instructions for you, but I can't release you at this time. So let me just stress that the rules that I've been reciting to you throughout the case continue to apply. Please don't talk about this case with anyone or allow anyone to talk about it in your presence. Don't express any opinions about the outcome. No media or independent investigation about these matters, and please have no communications with parties, witnesses, or lawyers. I'm going to ask that your notes and your jury instructions be placed in an envelope, and the clerk will seal those and hold those in the event that we need further services from Mr. Ryan, but I'll just simply ask that that be taken care of. So thank you very much. If you'll retire to the jury lounge on the 3rd floor and await further instructions from us, sir. Thank you very much. All right, ladies and gentlemen, we will be at ease with respect to this matter. I would ask counsel to remain nearby in the event we have a question or a verdict.
We do have permission to leave the court.
Yes, just remain nearby. Let the clerk or the bailiffs know where you are in case we need to gather quickly to address anything that the jury may require our attention to.
Chair, stands at ease.